But it is at this time I ask John Barrett to come forward. You all know who he is.
Thank you, Jim, and thank you, friends. Mr. Chief Justice, thank you again for your presence here. I'm here in a Paul Harvey-like capacity. Now the rest of the story. You'll remember that I mentioned in my remarks this morning outside the sabotage case that became Robert Jackson's first big piece of litigation 100 years ago this month. And really, this is for Jamestown. There's a small display and description of this upstairs. But I think this episode is an interesting one. Alas, not a federal case, Your Honor, merely a state criminal prosecution, but something that really is formative in the Jackson story. And so I just wanted to walk you through the timeline with the headlines of the Jamestown newspapers. The Jamestown landscape of literature, if you will, at that time, as in many cities, was both a morning and an afternoon paper. I grew up in Milwaukee, and I was a paper boy for the Milwaukee Journal, an afternoon paper, and the Milwaukee Sentinel was the morning paper. And today's there's the Journal Sentinel, and it's less than it once was. Jamestown had the Morning Post, and it had the afternoon Jamestown Journal. And of course, today it has the Post Journal. In these days, the Morning Post was a Democratic paper. And the Jamestown Journal, the afternoon paper, was a Republican paper, if you will. Now, I might be oversimplifying, but there was a more pro-labor perspective in the morning paper and a more pro-streetcar company perspective in the afternoon paper. This strike that began in May of 1913, interestingly, having spun a lot of microfilm over at the Prendergast Library, is covered very little in the Morning Post. On the other hand, the afternoon Jamestown Journal has headlines just short of Pearl Harbor attack size. And that's the imbroglio, activity, vandalism, arrest, and criminal defense that becomes this Jackson case. And I wanted simply to share with you some of the Jamestown Journal, Jamestown Evening Journal afternoon paper headlines. It begins on May 1st. Strike was declared at early hour today, and it's just a little front page box. And then shortly thereafter comes 8 men arrested on very serious charges, which is the description of the vandalism. They did it not downtown where I think the policing was more of an issue. They went sort of up the lake and in the Lakewood area and so forth, where the traction lines and the trolley companies reached all the way up to Chautauqua, indeed to Mayville. That's where they chopped their poles and cut the wires and wedged the switches and so forth. The next day, 5 men confessed to damaging property on street railway lines. You can see the momentum of prosecution. Meanwhile, another wild night of riot in the streets of city on Monday. And then 3 nights of riot make strenuous work for police and sheriff. Perhaps the afternoon paper was also law enforcement's paper. And then soon grand jury convened in Mayville. And then indictments returned in grand jury at Mayville. And then an interesting box on the front page which says, Frank Mott appointed to position. You see, Frank Mott was the Jamestown lawyer who Jackson was apprenticing for. Frank Mott was a Democratic politico, represented the Labor Council, did all manner of litigation. And in that June 1913 period, a new Democratic governor in the state of New York, William Sulzer, nominates Mott to be the counsel to the State Public Service Commission. That's an Albany job, and that's what pulls Mott into the political orbit and out of the practice orbit. The arraignments are where Jackson makes his appearance. He does what every good lawyer, at least on the defense side, I think, knows to do: request an adjournment, a postponement, a delay. And so this June to July problem becomes a resumption at the next term of the court in September. And that's when Jackson, still not admitted to the bar, petitions for leave of court to be permitted to defend these attorneys. Now, why wasn't Jackson admitted to practice? He was 21. He had taken and passed the New York State bar exam earlier in 1913. The answer is that New York State required 3 years of law preparatory training before one could be admitted to the bar. Counterpart rules are in effect today, and most satisfy it in law school. Jackson, of course, had spent only 1 year in law school, and before that a year as an apprentice, and now was late in, but still in, a second year as an apprentice. He needed to get to November to satisfy the 3-year clock, at which point his bar result and his 3-year duration would be the basis for his application, and indeed his admission in the 4th Department to practice. But he's 2 months before that. He asked Judge Ottaway, who's presiding at Mayville, to let him take over this defense. And the district attorney, a fellow named Green, readily consents. I said that in passing this morning. Jackson, late in life, ruminated about what joy the district attorney had, what alacrity with which the district attorney consented. You want to be represented by a non-lawyer kid? By all means, the state has no objection. And so that is the granting of the motion, and then that's the commencement of the first trial. Jackson's client was actually a fellow named Gaynor. The cases were being tried in a serial fashion. And the DA presents his first 4 witnesses and then rests, at which point Jackson makes his motion under New York's penal law, which prohibited cases based on solely accomplice testimony. In other words, cooperators, people who had cut a deal, no independent witnesses. It's a cousin, perhaps a distant cousin, of the 2-witness rule in the treason clause, literally in the Constitution. There's a sort of value of independence and absence of bias in evidence in our constitutional structure and in state laws, and that's what Jackson takes advantage of. The DA is flabbergasted by this motion, but recognizes that the charging document in the case he presented exactly fell into this legal bar of New York state law. And so he loses the motion, the directed verdict of acquittal is given, and then the DA null prosecutes virtually all of the other sabotage cases. So Jackson wins this one case, but in a sense it's the collapse of the entire prosecution of the strikers. And what's interesting is that one of the very impressed people is Mr. Broadhead, the chairman of the Jamestown Street Railway Company. Mr. Broadhead was a great businessman and also apparently not prone to generous wage increases. That was the genesis of the strike and all the legal trouble that ensued. And at the end of this process, I unfortunately don't know much about what happened to the strikers who became the defendants, but I do know that A.N. Broadhead became a Robert Jackson client. Jackson ended up doing corporate work for the Street Railway Company, estate work for the Broadhead family, and indeed sort of personal friends and relations were what developed there. And so it's an interesting glimpse of sort of starting small and working diligently and knowing your stuff and being ready, leading onward and upward to big things. And my connection, Mr. Chief Justice, as you grace us and honor us with your presence, is to the Jackson Center. The Jackson Center was an idea. Maybe a harebrained idea is the way to describe it. I was getting started writing law review articles about Robert Jackson. That's who I'm talking about. And I called a gentleman, Harold Adams, now deceased, who I had located as a name in some Jackson materials and knew he was Jackson's surviving nephew. And I knew he was in Jamestown, New York. Some of you have heard me describe knowing that Jamestown was upstate, and I got out a New York State atlas, and I ran my finger up the Hudson River. I just could not find Jamestown. Kept getting to Canada and starting over, and then I located it out in Cleveland. So I called Harold Adams, and he was charming, and he told me memories of his uncle, Bob Jackson, and then he said, there's a Jamestown lawyer you should talk to, Greg Peterson. He's interested in Jackson. He has an idea, Greg, I have the notes, of a Jackson Institute, was the phrase that Harold Adams used. And so I called Greg. That was late 2000. That was literally when the benefactors and the original fundraising was taking shape. And from that early moment, that youthful moment, that not yet admitted to anything, not yet qualified to do anything, moment of brilliance and vision and preparation over the ensuing 12 years has grown this center and this series of accomplishments, this testament to a great life, the teaching that we're all committed to, and the presence of the Chief Justice of the United States. Thank you, sir.